Good afternoon and welcome to this webinar examining what we call the Rules of Disengagement. What happens when someone leaves your business? I'm Ray Welling, Editor-in-Chief of WorkplaceInfo, and I'm joined today by two guests from the Fair Work Ombudsman, Catherine Duff, Senior Education Officer, and Scott De Silva, Senior Research Officer. Catherine, Scott, welcome. Now, as we get underway, I just wanted to remind you that if you have any technical issues, or if you'd like to post a question to our panelists, you can do that by typing your query into the chat box in the lower left corner of your screen. Now, we've received quite a few questions in the lead up to this webinar, and we'll get to as many of those as we can during the time we have together or as follow-up. I'd also like to point out that the information provided in the webinar today is general information only, so it does not take into account your own particular work situation or your objectives and needs. Before acting on any information contained in this discussion, you should consider the appropriateness of the information, having regard to your own objectives, work, financial situation, and needs. Now, Catherine, let's start by explaining the role of the Fair Work Ombudsman. Can you fill us in on how your team works?
Thanks, Ray. Scott and I appreciate the opportunity to present on this topic. Thank you all for making the time to join us today. Working at the Fair Work Ombudsman, Scott and I have become familiar with the common issues employers come up against when dealing with termination of employment. We hope that the insights we provide today will be useful to you all. Let's start, as Ray mentioned, with a bit of an overview of what we're going to discuss in today's webinar. First, we're going to talk about the role of the Fair Work Ombudsman in dealing with termination of employment matters. As part of this, I'll discuss the role of the Fair Work Commission and where our roles intersect and differ when it comes to matters of termination. Next, we're going to take you through the key requirements that apply to terminations which fall under the Fair Work Ombudsman's scope. The 5 key areas we're going to look at today are notice of termination, redundancy pay, calculating an employee's final pay, making a proper record of the termination, and the general protections as they relate to dismissals. As we look into each of these 5 areas, I'm going to take you through the basics on each topic. Scott will then take you through some of the common questions we receive from employers and managers about how the provisions apply in practice. Finally, we'll let you know about the free tools and resources that the Fair Work Ombudsman has available. These will help you manage termination issues at your workplace. Most of you will be familiar with the Fair Work Ombudsman, but I'd like to briefly revisit this so I can explain what our role is in relation to termination. The Fair Work Ombudsman is Australia's national workplace regulator, and our role is to promote compliance with the Fair Work Act. The Fair Work Commission, on the other hand, is Australia's national workplace relations tribunal, previously known as the Fair Work Australia, and before that, the Australian Industrial Relations Commission. In relation to termination, the FWO deals with entitlements payable on termination, notice of termination, redundancy pay, record keeping, and general protections. In relation to these matters, our role is to provide advice and assistance. We do this via our Fair Work info line, our website content, and the education activities we engage in. We also monitor and enforce compliance. We do this by conducting audits and investigations, providing assisted resolution services, and conducting litigation where necessary. On the other hand, the Fair Work Commission deals with unfair dismissal, unlawful termination, and general protections. In relation to the above matters, the Fair Work Commission's role is to deal with and resolve disputes about termination. They do this through mediation, conciliation, and arbitration. You'll notice that both the FWO and the Commission deal with general protections. I'll explain how our role in relation to these is different when we cover it later in the presentation. So, let's begin with our first topic, notice of termination. As many of you already know, notice of termination forms part of the 10 National Employment Standards, or the NES. An employer must provide their employee with written notice of termination before terminating their employment. The notice of termination can be delivered personally, left at the employee's last known address, or sent by prepaid post to the employee's last address. Not all employees are entitled to receive notice of termination. For example, casual employees, those on a fixed contract, or those terminated due to serious misconduct are not entitled to a notice period. The amount of notice that is required to be provided by the employer is based on the employee's age and their length of service. If the employee is 45 years or over, they receive an additional week of notice, provided they have worked with the employer for at least 2 years. An employee's service, or continuous service as it is known, is based on the length of time the person has been employed by the business. It's important to remember that this excludes any periods of unpaid leave, like unpaid parental leave. While casuals are not entitled to receive notice, a full-time or part-time employee who may have converted from their casual employment will be entitled to have their period of casual service counted for the purposes of determining their entitlement to notice. If the employee does not wish for the employee to work out their notice period, they can provide payment in lieu of notice instead. The amount paid must be at least equal to the amount the employee would have been paid if they had worked until the end of their notice period. And finally, as with all entitlements that are derived from the NES, it's important to check the award or the agreement and or the contract which covers your employee, as this may contain additional or different requirements about notice. For example, the Professional Employees Award requires the employer give 1 month's notice of termination, regardless of the length of the employee's service. I also want to briefly touch on the notice requirements that apply to employees when they resign from their employment. These may be different to those that apply to employers. Employees are not obliged to provide notice of termination under the NES. Additional requirements may come from an award, an agreement, or a contract. Many awards stipulate that the amount of notice to be provided by the employee must be equal to that required for the employer. Generally, an employee does not need to provide notice in writing, though again, this will depend on the terms of their industrial instrument. Often, an award, agreement, or contract will allow the employer to withhold any entitlement owing to the employee if they do not provide the correct notice. Now I'm going to turn to some frequently asked questions about notice of termination. I'm going to ask Scott to answer these questions, and the reason why we've flagged these particular questions is that they're ones which we very often receive at the Fair Work Ombudsman. So our first question is, do I have to give notice if the employee is on probation?
Yes. A probation period is not a separate or distinct period of employment. Under the Fair Work Act, employees on a probation period are still eligible for the same entitlements that they would receive if they weren't on probation, including notice of termination.
Do I have to give notice to a fixed-term employee if they are terminated before the end date of their contract?
No. Employees on a fixed-term contract are not entitled to notice of termination under the National Employment Standards, even if they're terminated prior to the specified end date. However, a registered agreement or a contract of employment may say otherwise.
Is the notice valid if I haven't provided it in writing?
Yes, the notice is still valid. However, this is a breach of the National Employment Standards, so a civil penalty may apply. It's important that an employer remembers to give notice in writing.
If I give more notice than required, does the employee have to work out the excess notice period?
No. However, if the employee gives more notice than required of their award, their enterprise agreement, or their contract, you can accept the longer period, In this case, the employment ends on the final day of work as agreed, or not accept the longer period. The employment ends on the last day of the minimum required notice period. You should let the employee know whether you accept the longer period of notice or not within a reasonable period of time. Both parties should be clear about the employee's last day of work.
What if the employee wants to leave before the end of their minimum notice period?
If an employee wants to leave in these circumstances, the employee must resign. They would still be subject to any minimum notice periods under an award, an agreement, or a contract. If this notice period is not provided, the award, agreement, or contract may allow the employer to withhold entitlements owing to the employee equal to the notice which should have been provided. In these circumstances, we recommend you discuss the notice period with your employee and agree on an end date.
Now, some more questions. Can the employee take leave during the notice period? This is a question we receive very often on our info line, and we know it might be of interest to many of you.
Yes. An employee can still take their leave entitlements as per normal, provided they meet requirements such as giving adequate notice for annual leave or a medical certificate for personal leave. An employer, however, cannot direct an employee to take leave during the notice period.
Can the notice of termination run at the same time as a period of pre-existing leave?
This really depends on the type of leave and who gave notice. With a period of pre-approved paid annual leave, the employee can use this period for notice, but the employer can't. With unpaid leave, it really depends on the kind of leave, the kind of unpaid leave.
What if the employee is terminated while they're on workers' compensation?
The employee should receive pay in lieu of notice. Workers' compensation doesn't override the employee's entitlement to notice. They are separate entitlements.
And what if an employee gives notice and I want them to stop working before the end of the notice period?
If an employer wants an employee to leave before the end of a notice period that the employee is provided, notice basically resets, and the employer is up for another period of notice. So for example, if Sally worked for Fred for 5 years and gave 4 weeks notice, then a week later Fred decided that it wasn't working out and tells Sally to leave straight away, Fred has terminated Sally, and now Fred has to give 4 weeks notice himself, or pay 4 weeks in lieu of. Just like I mentioned earlier, where we have an employee who wants to leave earlier, now having to resign with the proper notice period or face a deduction, Fred now has to provide a new notice period.
And finally, this is a question which is very common for us. Do apprentices and trainees receive notice of termination?
It depends on how the apprentice or the trainee is engaged. So unless an apprentice or a trainee is specifically engaged for a specified period of time, notice of termination will apply.
Okay, thanks, Scott. Let's move now on to our second topic, which is redundancy pay. Like notice of termination, redundancy pay is one of the 10 National Employment Standards. Redundancy pay is payable when the employer terminates an employee's position because the employer no longer requires the job to be performed by anyone due to operational requirements or because the business has become insolvent or bankrupt. Redundancy does not apply in a number of situations. These include employees who have less than 12 months service, businesses with fewer than 15 employees, if the employee is a casual employee, or if there is an industry-specific redundancy scheme that applies to the employee. When we talk about termination, we mean the termination of the employment contract. This means an employee can have their position made redundant, move to a different position in the company, and still be entitled to redundancy pay. They don't have to leave the business. We'll touch on this in more detail soon. Now, the following table shows the minimum amounts of redundancy payable under the NES. Check if your award contains industry-specific redundancy provisions. If your award does this, those provisions will apply instead of the table above. For example, there are provisions in the Building and Construction Industry Award which apply rather than this table. Awards with industry-specific redundancy provisions can be different to the NES and often do not have as many exclusions. For example, the industry-specific redundancy scheme under the Building and Construction Industry Award has provisions which entitle employees of small businesses or employees with less than 12 months service to redundancy pay in certain circumstances. Looking at the table, you might be wondering why the amount of redundancy falls to 12 weeks after 10 years of service. This relates to the fact that long service leave entitlements also come into effect for most employees after 10 years of service. So historically, the redundancy entitlement has been adjusted to take this into account. Now let's look at the basics of redundancy pay. Redundancy pay is calculated at the employee's base rate of pay for ordinary hours worked. What this means is that it does not include bonuses, loadings, allowances, overtime, or penalty rates. Under the NES, the maximum working week is 38 hours. So even if an employee works 40 hours a week on a continuous basis, their redundancy entitlement under the NES will be paid out at 38 hours a week. So let's move now to some frequently asked questions about redundancy pay. Scott, what is the redundancy provision? What if the redundancy provisions under my instrument are different to those under the NES?
We're focusing on the NES for this presentation, but awards, contracts, enterprise agreements are all other possible sources of redundancy pay that might apply. Check to see what applies to you.
And the question which I touched on earlier and said we'd return to, does redundancy pay apply if I find my employee another job?
Yes. However, if an employer obtains acceptable employment for the employee, they can apply to the Fair Work Commission for an order to reduce the redundancy pay that would be owed. If granted, the order can reduce that amount to nil. Acceptable employment involves more than the salary offered. The cases have looked at the following factors: the status of the new position, the pay, the hours of work, the location, the travel times, job security, the nature of the employment, and the skills and qualifications. In one case, even an offer to transport employees from their homes to the new site where the other job was not enough for the employment to be deemed acceptable. The lodgement section on the Fair Work Commission's website contains the form to apply for an order to vary redundancy payments.
And does an employee still get redundancy pay if they leave during their notice period?
Most modern awards say that an employee will get redundancy if they leave during the notice period. However, an award-free employee who resigns within the notice period will not be entitled to redundancy pay under the NES. It's considered in this case that they've actually left the employment of their own choice during the notice period, and so the termination of employment is at their initiative. Employees covered by a registered agreement or an individual of contract may have different conditions altogether, so it's important to check these.
And this is another tricky question which we receive a lot. Does redundancy pay apply when there is a transfer of business?
This will depend on the circumstances of the transfer. So if the new employer does not recognise an employee's service with the old employer, the employee will be entitled to redundancy. An employee, however, will not be entitled to redundancy when they reject an offer of employment from the new employer where the terms and conditions are substantially similar to, and on an overall basis is no less favourable than the employee's terms and conditions with the old employer, and the new employer recognises the employee's service with the old employer, and if the employee had accepted the offer, there would have been a transfer of employment in relation to the employee. Now, if these conditions are not met, the employee is still entitled to redundancy pay from the old employer.
Does the notice period count as continuous service in determining redundancy pay entitlements?
Yes, if the employee works out the notice period. In that case, this counts as continuous service for the purpose of determining redundancy pay. However, if an employee has less than 12 months continuous service at the time notice of termination is given, and working that notice of termination would take them over 12 months service, then the employee has no entitlement to redundancy. In circumstances where payment in lieu of notice occurs, service is counted up until the last day of employment, not the last day of the notice period that would have otherwise
Let's move
applied.
to our third topic, final pay. Final pay is the amount owing to an employee when their employment ends. This is usually paid on the last day of employment or on the next scheduled pay day. Check your industrial instrument because sometimes they contain specific provisions around this. Final pay includes outstanding wages for hours worked, including any penalty rates and allowances. Accrued annual leave, including annual leave loading if it would otherwise have been paid, any accrued or pro rata long service leave pay, pay in lieu of notice if this applies, and redundancy pay if relevant. If you are paying in lieu of notice, the employee does not accrue leave entitlements. Okay, that brings us now to our frequently asked questions around final pay. Is annual leave loading still payable if my award says that it's not?
Yes. Some awards, like the Vehicle Manufacturing, Repair Services and Retail Award, indicate that annual leave loading is not paid on termination. Despite clauses like this, employees are still entitled to receive leave loading.
Can I
as a Fair
withhold
Work Act
money
overrides
from an
such
employee's final pay if they do not provide the minimum required notice to me?
Yes, but only if it's stipulated in an award or an enterprise agreement. The Fair Work Act allows deductions from employees' pays, but via a specific framework. This means things like till shortages can't be withheld from a final
If an
pay,
award or
even if they're
agreement
the fault of the
allows me to
employee.
withhold pay for insufficient notice, how much can I withhold?
This will vary, so you have to check your award or agreement. Generally, it will be equal to the amount of notice.
Thanks, Scott.
not
Now
provided.
let's move on to our fourth topic, the keeping of termination records. When a termination of employment occurs, it is a requirement under the Fair Work Act that a record be kept. This is a separate requirement to the provision of written notice. The record of termination should include how the termination occurred, the manner in which it occurred, if notice was provided, and if yes, how much, and the name of the person who terminated the employment. Records have to be kept for 7 years from the date they were made. They need to be kept in English and be legible. While it is not a requirement of the Act, we say it's also best practice to keep a record of the reasons behind the termination of employment. This might include records of any meetings or performance management documents connected to the termination. This can assist if the employee claims the dismissal was unfair or was a breach of general protections. So let's move now to our frequently asked questions around termination records. Scott, what happens if an employee resigns? Do I need to keep their notice?
No. Neither the Act or the regulations explicitly require an employer to keep an employee's notice of resignation. However,
now a former
employers may
employee
wish
has
to
asked
consider
me
taking
for a
this step.
separation certificate. What do I have to do?
Separation certificates are documents required by the Department of Human Services so that an employee can access unemployment payments. Separation certificates are a common inquiry that we receive at the Fair Work Ombudsman, but it's important to note that it's not a document which is issued by the Fair Work Ombudsman or enforced by the Fair Work Ombudsman. Employers, employees, and representatives should visit the Department of Human Services website to download the separation certificate and to find out more information on how they work.
Thanks, Scott. Now, the final topic which we're going to cover off on is general protections. The general protections provisions are relevant to the circumstances of a termination. We're going to cover this because the Fair Work Ombudsman has power to enforce these provisions, as does the Fair Work Commission. The general protections in the Act set out a number of actions which are prohibited when taken in relation to particular rights or attributes. These include adverse action, coercion, undue influence or pressure, and misrepresentation. These prohibitions are not limited to actions taken by an employer in an employment context. They are broader than this and extend to actions taken against, and in some circumstances by, independent contractors, industrial associations, and prospective employees. We won't go into all of this today, but what I will do is cover the areas that are relevant in the context of a dismissal of an employee, which are adverse action and coercion. So let's take adverse action first. Taking adverse action includes dismissing an employee, injuring their employment, altering their position to their detriment, and discriminating against the employee. A dismissal can be deemed to be adverse action if the dismissal occurs because the employee has or is exercising or is proposing to exercise a workplace right. We'll talk about that a bit more in a moment. Is or is not a member of a trade union, is or is not engaging in industrial activity, or has a protected attribute, which is another way of describing discrimination. In addition, an employer cannot dismiss or threaten to dismiss an employee in order to hire them as an independent contractor, doing the same or substantially the same work. Many of you will know that this is described as sham contracting and is specifically prohibited by the Act. So let's talk a bit more, as I mentioned, about workplace rights. Workplace rights include receiving a benefit or having a role or responsibility under a workplace law. So any of the entitlements in the NES underneath the Fair Work Act would be an example of this. A workplace instrument can also give someone a workplace right. A workplace instrument can include a modern award or an enterprise agreement. This may be things like rest breaks or rostering entitlements of the employee. Or it can be a workplace right which comes from an order made by an industrial body, such as an order made by the Fair Work Commission. And this might include orders made by the Commission with respect to the details around someone's employment following the lodgement of a matter with the Commission. Workplace rights also include commencing or participating in a process or proceeding under a workplace law instrument, and this would include taking court action or lodging something with the Fair Work Commission. And workplace rights also include being able to make a complaint or inquiry about your work employment rights. That could include an inquiry to the Fair Work Ombudsman or even to someone's union. So let's discuss now some frequently asked questions relating to adverse action. Scott, can I dismiss an employee because they lodged a complaint with the Fair Work Ombudsman?
Employees have the right to make a complaint about their employment, and dismissing an employee for this reason is adverse action.
And can I dismiss an employee because they're a member of
No.
a union?
Employees have a right to freedom of association, meaning they are free to be or not to be a member of a union without it affecting their employment. To dismiss an employee for this reason would be adverse action.
And can I dismiss an employee because they took part in lawful industrial action during the enterprise bargaining process?
No. Employees have a right to participate in a process under a workplace law, such as protected industrial action. To dismiss the employee for participating would be considered a breach of the employee's general protections.
And can I target an employee for redundancy because of something like their ethnicity, their pregnancy, or their age?
No. An employee's race, colour, national extraction, or social origins are all protected attributes under the Fair Work Act. Therefore, Taking an adverse action against an employee because of one of these attributes would be considered a breach of general protections.
Okay, so let's turn now to coercion. Coercion means forcing someone to do something that's against their will, for example, through the use of fear, intimidation, or threats. This can include threatening to dismiss someone. An employer cannot coerce an employee to exercise or not exercise a workplace right or exercise it in a particular way. Examples of coercion have included threatening to dismiss an employee because they refuse to vote up an enterprise agreement, they don't agree to an individual flexibility arrangement, or they want to lodge a complaint with the Fair Work Ombudsman. For example, if an employee refuses to vote up an enterprise agreement, the employer can't threaten to sack the employee, threaten to demote the employee, or change their roster. So let's have a look at some of the frequently asked questions that we receive at the Fair Work Ombudsman around coercion. Is adverse action the same? Sorry, I just want to check I'm in the right spot for you all. Oh yes, now I just want to turn to some more generic FAQs around general protections. Is adverse action the same as unlawful termination?
No, not all adverse actions involve a termination of employment.
So can you tell us who deals with general protections complaints? Is it the Fair Work Ombudsman or the Fair Work Commission?
Both agencies deal with general protections complaints, but there are some differences. If an employee is considering making a general protections complaint in relation to a dismissal through the Fair Work Commission, there's a 21-day time frame. Further, the Fair Work Commission can order compensation, but the Fair Work Ombudsman cannot. The Fair Work Ombudsman can decide to conduct an investigation to determine if a breach of general protections has occurred, and if it has, will consider appropriate and proportionate compliance outcomes, which can include seeking penalties at court against an employer. Anyone considering making a general protections complaint should contact both the Fair Work Ombudsman and the Fair Work Commission so they can decide which body is more suitable for their complaint.
Okay, thanks Scott. So let's turn now to the resources that are available on our website for assistance with matters relating to termination of employment. We'd like to tell you a bit about those resources and encourage you to look at them because it's good to know from the people who've been using them that they do help our customers with managing termination of employment in their workplaces. The first is our relatively new Pay and Conditions tool, which is also known as PACT. It has a notice and redundancy calculator. The tool will help you to determine not just the NES entitlements that apply in a termination of employment scenario, but also take account of any award-specific provisions that apply. The way that the calculator works is that you're able to select your award or the award or agreement under which the employee works, and the tool will then assist you to calculate redundancy and termination entitlements, taking into account the specific clauses that apply in that award. We would strongly encourage you to use that tool when you are calculating final pays in situations where the employment relationship has ended, because it's a great way to not miss anything which specifically applies in the instrument governing the employment that you're bringing to an end. We also have a range of templates available to download from our website. These include template letters of termination and also documents to assist you with managing performance, such as the steps to take when undertaking a performance meeting and warning letters. You can access all of these templates at www.fairwork.gov.au/templates. We also have very helpful online learning courses specifically to help you manage performance in your workplace. This course steps you through the process of setting up a performance system at your workplace and also the steps to take when managing an underperforming employee. You can find this course at our website at www.fairwork.gov.au/learning. We encourage you also to sign up to our My Account service on the website. Many of you may already have done that, but let me just recap the benefits of doing that. You can create for yourself a knowledge portal and save in there all of the information that you often search on our website. You can save specific templates and other resources that you may wish to return to, and you can also save there your calculations made through the tool. The great thing about that is that if the pay rates change or amendments are made to an award, you can set up alerts to be advised if those entitlements have changed. That's a great way to keep up to date with your award as it applies to your employees, but also to keep track of the rates you should be paying each of your employees based on the award under which their employment is governed. The other thing about My Account is that you have exclusive access to FWO Knowledge Connect, which is the collaborative online space where industry can provide us with information about the way the awards are working in practice. It's a way for us to gather industry knowledge and real-world experience about workplace relations issues. We use this feedback to help us inform our positions, and often post specific articles on Knowledge Connect seeking feedback from industry stakeholders around the way that particular issues are working for them. We've posted articles on a number of issues, including notice and redundancy. All of them are currently waiting for industry to share their stories, so it's a great way for you to get online and have your say about these important issues. To access Knowledge Connect, you can go to the website and create a My Account, or if you're already a My Account user, you'll be able to find a big radio button in the left-hand navigation in My Account, which lets you open up the Connect functionality and see the articles and begin commenting. Hopefully you'll find all of these resources useful. We're always updating and releasing new resources to make it easier for you to meet the requirements of the Act. We also like to invite our stakeholders to provide us with information around gaps in our resources and on our website content. If there's any particular issues, particularly around termination, notice and redundancy, which you think could be addressed with a specific resource or with further information that you can find on the website, we would encourage you all to let us know about that. There is a facility in the Connect space for you to provide us with information that goes to that, and we would be grateful for information around that. So that brings us to the end of the formal part of the presentation, and I'll now hand over to Ray for the rest.
Well, thanks very much for that. That was incredibly informative. Now, at the time we've got left, we'd like to tackle some of the questions that have come through from participants. And I'll just throw that out there, and you guys can work out which of you would like to answer them. The first question that we had was, in a redundancy, how long is the wait until the position can be reused or re-employment?
This is a very important question, and one we receive very often on the info line. Under the Fair Work Act, there's no specified period of time an employer has to wait between making a position redundant and then later advertising. However, employers should note that an employee who was made redundant may be able to lodge an unfair dismissal claim or a general protections claim if they doubt the genuineness of the redundancy. So there's always a risk involved in re-advertising the same position promptly after someone's been made redundant. If the redundancy was a genuine redundancy, then there are perhaps ways in which the re-advertised position will look different from the position that the person who was made redundant used to do. And it's an important thing for you to remember in situations that if you have made someone redundant, that you need to manage the risk of how it may appear to the person who has been made redundant should the position suddenly be soon afterwards re-advertised without changes. So just something to bear in mind, to remember that redundancies must always be genuine, and if a business decision has been made to make a position redundant, you need to just bear that in mind should you wish to re-advertise.
Mm-hmm. Okay, another question we had related to calculating redundancy payments. Now, they asked, how does the redundancy payment calculation work if you've got part-timers or you have employees who are switching from full-time to part-time after returning from something like, say, for example, maternity leave? The example given, they said in particular where there's a long service leave payout, if an employee is entitled to, say, for example, 5 weeks of long service leave, how do you form the calculation if at this stage the employee is now a part-timer, only working like 20
Under the National Employment Standards, redundancy is based on the position of the person at the time the redundancy occurs. So if the employee had been full-time for 4 years, gone on a period of parental leave for 1 year, and then came back as a part-time employee on, say, 20 hours a week, the redundancy payment would be based on that 20 hours a week at the time they got made redundant. Long service leave, however, may be different because it depends on where the long service leave entitlement is coming from. We recommend that employees in this situation clarify where the employee's long service leave entitlement is actually coming from. It could be from state legislation, it could be from an enterprise agreement, or it could be from a previous award that used to apply. It's also important to note that at this point in time, the National Employment Standards don't actually provide a specified long service leave entitlement.
Can I just add one thing to Scott's answer? I think that this is a common misunderstanding of employees. If they've worked full-time and then they come back part-time in particular, and then they're made redundant, many of them understand that they should be paid their redundancy pay based on their service as both a full-time and a part-time employee. But in practice, what the NES requires is that they be paid their redundancy only at the rate of pay that they are currently working by the number of weeks. And so it's often an issue in which there is a dispute between the redundant employee and the employer. So it's very good to be on solid ground when you're having these conversations with your employees. Should they raise this issue, it's good to be well prepared with the information about why they're receiving the 20 hours times, for example, 5 weeks, as opposed to 3 weeks times 30 hours plus 2 weeks times 20. So I think it's a good thing to have worked out the calculations beforehand, to have a good understanding of how they work, and then to present that to the employee at the time that you give them notice with respect to the redundancy payment. Obviously, the calculator on our website will also be a good backup for you when you are calculating these pays, and you will be, when you make that calculation, you're in a position to export the calculation and to print it out as a PDF with the Fair Work Ombudsman's letterhead. So that's always a good resource to have at hand when you're having these conversations around the amount of redundancy pay.
Yeah, no, that's very helpful to have that information. But just to clarify, you mentioned that the redundancy payment is based on the situation at the time of redundancy, but if they've accumulated
Correct.
the long service payment at the full-time rate,
that will still apply.
Payment is
yes,
made.
It's the redundancy which is based on their number of hours at the time that they are made redundant. As Scott mentioned, the long service leave is governed based on their actual service.
Right, okay. Okay, another question we had was, should a fixed-term employee's contract end date need to be brought forward? What reasons should be given? And how does that need to be recorded?
This is a common question that we receive on our Fair Work Info line as well. Each termination situation is different. And on the slides in the presentation that we've provided today, it's demonstrating the information that has to be kept. Beyond this, the judgment does rest with the employer as to whether they should keep any records beyond what has to be kept. Now, the Act doesn't specify that an employer has to give a reason, but this can cause employers difficulties in relation to general protections complaints and unfair dismissal complaints if employees take the step of lodging these kinds of actions. We would recommend that employers in this situation consider the implications of not providing reasons, as well as completing our online learning module on difficult conversations.
Okay. Now, another question which I've also noticed has come up, both beforehand and during the course of this webinar. What can be done if property isn't returned at a time when someone's leaving? Can the cost of that come off the final payment due to the employee?
Now, this is also a very common question that we receive at the Ombudsman, and we understand that for employers it's a very important one, as sometimes property can be very valuable. If an employer wanted to take the value of the property out of someone's final payment, the issue is whether or not a deduction is authorised. Under the Fair Work Act, as Scott touched on earlier, the ability of an employer to make deductions is strictly regulated. Unless this kind of deduction was authorised in an award or a registered agreement or in a contract of employment, the employer would need to get the employee's consent in writing to make the deduction, ensure that this document specified the amount and the date that the deduction was occurring, or ensure that the deduction was for the benefit of the employee. As you can imagine, in most cases when you're trying to collect money with respect to property, you would be unable to make out these three requirements underneath the Fair Work Act, and the deduction would not be authorised. The employer, even though this is an unsatisfactory answer probably for many of you listening today, the employer would be able to pursue the employee civilly or criminally, but we would always say you need to get legal advice around this issue rather than to withhold from the employee's final pay.
Right. Okay. In other words, it's always a bit more complicated
Absolutely.
than what it looks like on the surface.
And I should also say, Ray, there may be many employees who are happy to have the conversation about returning the property. And even if we find in our work, even if the employment relationship didn't end as well as it could have been hoped, in the fullness of time, a conversation can be had about the return of property. And sometimes we facilitate those conversations, and sometimes, and indeed in many cases, the employer and the employee are able to sort it out themselves with a bit of assistance from us. But we would say, even though it would seem easy to withhold from the final pay, that can be actually in the end quite painful for the employer. And so we would say, if you do have a situation where someone isn't returning property and it's become intractable, seek some further guidance about what to do next.
Okay. All right, I think we've got time for a couple of more questions. One that's come through is someone was asking about the financial implications when employees fail to give required notice. Talking with regards to
this would depend largely on the
contracts.
terms of the contract. So in these situations, both parties should really seek legal advice on what implications can actually arise contractually if the employee failed to give notice. It's important to remember in these situations that common law contracts don't replace the national employment standards or an award or registered agreements. So check the applicable industrial instrument first, then check the national employment standards. If the employee wasn't covered by an award or a registered agreement, given the NES doesn't contain a financial penalty for an employee who doesn't give notice, then it would really depend again on the terms of the contract.
Okay. Now, what needs to be done, both in terms of what your legal obligations are and what's best practice? So what needs to be done to terminate an employee that has worked for the company for more than a year, but you want to terminate them due to poor performance?
This is also a very common question for us on the info line, particularly from small business owners. The Fair Work Act doesn't really set out a specific procedure on how to terminate an employee. In terms of performance management, We always recommend that employers and employees consult our online learning centre and undertake the difficult conversation modules. These modules are tailored for both employers and managers and employees. Beyond this, employers should, if they're considering terminating, consider whether or not the Small Business Fair Dismissal Code checklist applies to their business. It contains a number of things that would be helpful to an employer if they wish to terminate an employee in circumstances of underperformance. This checklist is available on the Fair Work Commission's website. The FWO also, on our website, we also have template letters available that go to termination based on underperformance, and we also have information about managing an underperforming employee if you wish to continue with efforts to improve their performance rather than to terminate them immediately.
Okay. Now, if an employee is paid different rates for the work that's done, for example, a lower rate when they're working in the yard or off-siting in trucks and a higher rate when they're driving, what rate should these people be paid out when they're taking annual leave or having in lieu payments?
Usually in these situations, we look to the principal purpose of the employment. Was the employee engaged as a yard hand who occasionally drove a truck and got a higher rate of pay while doing that? If that's the case, then usually the lower rate, or the yard hand rate, would apply. The other thing to note would be that during annual leave, of course, the employee wouldn't be working. So that's something to bear in mind with kind of higher duty payments that employees may otherwise be attracting in the course of their duties. Okay,
well look, I think we might leave it at that. We've covered a fair few questions. I do apologize for any of the other questions that have come through during the course of the webinar that we aren't able to get to now. But if you head over to the Fair Work website, you should be able to find the answers to lots of those questions. And I think some of them were probably addressed during the course of the presentation. So Catherine and Scott, I'd like to thank you very much for your time. Now, we hope you found today's session useful. Please feel free to drop us a line at editor@workplaceinfo.com.au if you have any follow-up questions. And make sure you log on to Workplace Info and Workplace OHS for the latest information on compliance and best practices for HR, IR, and work safety professionals. If you want to revisit some of today's presentation, I will be publishing an archive on our YouTube channel to watch and listen to at your leisure, and the URL to that video will be included in our follow-up correspondence in the next couple of days. Meanwhile, keep an eye on your email inbox for info on our upcoming webinars, such as next month's webinar on safety inductions, where we'll be speaking to Canadian safety expert Stacey Hamilton. In the meantime, thanks for your time and best of luck with your work.